Assalamualaikum and good morning to everyone. My name is Ali Zikri and I will be the first presenter for my group of presentation. We'll be presenting a research titled as a comparative study on the granting of citizenship for adopted stateless children in Malaysia and New Zealand. Next, our proposal is divided into several chapters, namely the research background, the problem statement, the research questions, the research objective, the research scope and limitations, the research methodology, the literature review, and lastly, the significance of the research. So first, I will proceed with the research background. It is important for us to understand and decipher the true meaning of the stateless person. In accordance with Article 1 of the Convention relating to the status of stateless person in 1954, it is a person who is not considered as a national by state under the operation of its law. It includes foundlings and even children whose parents fail to register their birth. A prominent case of foundlings in Malaysia can be seen in the case of Rohana Abdullah, who was abandoned and then adopted by her Malaysian adoptive mother. She didn't acquire citizenship due to her mother being a non-Malaysian who was Indonesian, and her father, who she claimed to be a Malaysian, disappeared. Her story caught the attention of the Prime Minister Ismail Sabri, and he offered to help to assist Rohana, which is also at the same time being urged by Suhakam for the government to address the issue of granting citizenship to stateless children in Malaysia. After 7 years of applying, Rohana finally received her citizenship after such assistance. So there are others adopted parents who are struggling so that their adopted stateless children are granted citizenship by operation of law. Yet most of them still does not succeed. This is why there is a need to address the issue of granting of citizenship to adopted stateless children in order to uphold their rights and liberties. Next, we move on to the problem statement. In Malaysia, stateless children can be adopted via Adoption Act 1952 or Registration of Adoption Act 1952. However, both acts are silent regarding the status of citizenship of the stateless adopted children. The provision of citizenship under Part 3 and Second Schedule of the Federal Constitution are also silent and does not cover such matter. In the courts, however, there are two interpretations and judgments. In the case of Lee Chin Pon, the court enables the citizenship of the adopted parents to be automatically passed to their adopted children. In the contrasting case of Photon Aik, the court stated that adoption has no legal effect on citizenship status, and such decisions are endorsed by the National Registration Department and the Ministry of Home Affairs. Due to such endorsement, these adopted stateless children are not entitled to receive or to be automatically being granted citizenship by operation of law as covered under Article 14 of the Federal Constitution. The adopted parents are also needed to resort to the registration process, which from 2016 to 2021, only 21 out of 2,352 applications were approved. And being stateless would provide legal and social effects towards the children, such as deprived of their rights to education, free healthcare, and in terms of social effects, they can be alienated by the rightful citizens, and it will surely impact and damage the children's psychological state and mental health. That's all for me. I will pass the torch to Hakif.
Thank you, Ali, for the vast explanations. Now, I am Muhammad Nur Akif, and let's move on to research questions. The first research question is, what are the legal provisions relating to the granting of citizenship, specifically to adopted stateless children in Malaysia? Secondly, how does New Zealand deal with the granting of citizenship to adopted stateless children in comparison with Malaysia? Lastly, how to propose legal provisions governing citizenship to adopted stateless children in Malaysia? To obtain information on our research objective, I will pass the baton to Imran.
Thank you, Hakif. Moving on to the research objectives. We have limited our research objectives to three. The first being to analyze the legal provisions in relation to the grant of citizenship, specifically adopted stateless children in Malaysia. Secondly, to investigate the approach of New Zealand in the granting of citizenship to adopted stateless children in comparison with Malaysia. Third and last objective of our research is to propose legal provisions governing citizenship to adopted stateless children in Malaysia. Moving back to you, Akif.
Thank you, Imran. Now back to me for the scope of our research. It is acknowledged that there are many variants of stateless person. However, this study will be focusing on adopted yet stateless children only. As the name suggests, we will look at the law governing adoption. Therefore, the Adoption Act and the Registration of Adoption Act 1952, which governs adoption in Malaysia, will be examined along with the Adoption Act 1955 of New Zealand, which is the existing legislation on adoption in New Zealand. The study will be focusing on the types of adoption involved, the procedure for adoption, and the condition for a valid adoption. However, in examining the legislation, the study will be narrow to adoption of children who do not possess a valid citizenship or that their biological parents are not traceable only. Additionally, the law governing citizenship will be the primary scope of this study. Accordingly, Part 3 of the Federal Constitution along with the second schedule, which governs conferment of citizenship in Malaysia, will be analysed along with the Citizenship Act 1977 of New Zealand, which regulates matter on citizenship in New Zealand. The discussion on the granting of citizenship will examine the types of citizenship involved, the medium through which citizenship may be acquired, and the prescribed condition to receive citizenship status. However, the United Nations Conventions on the Right of the Child will also be succinctly explored in order to carve out authoritative reference on the right of the children to nationality. Notwithstanding the generality of the provision on citizenship, the focus of the research will be the granting of citizenship to adopted stateless children only. Lastly, the research will also cover the roles of the government institution which is responsible for adoption and citizenship. Therefore, the role of the Department of Social Welfare, the courts, and the National Registration Department in Malaysia will be analysed in comparison with the Ministry for Children, the courts, and the Department of Internal Affairs in New Zealand. The study will be focusing on the roles of these authorities in facilitating adoptions, the power of the courts in granting adoption order under the law, and the powers of the NRD and DIA respectively to grant citizenship. This is necessary to emphasize how the authorities determine the status of citizenship on the adopted children under each legal frameworks. To obtain information on the limitation of this study, let's move on to Imran.
Okay, with reference to the limitation that we have encountered during the period of our study, the lack of data available and reliability of data have been concerning. The absence of sufficient concrete information will limit the details of our analysis, especially regarding our comparative study. For instance, according to UHNCR 2021 data collection, there were an estimated of 112,420 stateless persons, while the estimated figure of refugees were 132,086. The UHNCR does not categorize such digits or figures into gender, race, religion, or age, but they do categorize such figures into the respective countries of their origins. Hence, making it quite difficult for us to ascertain Malaysia's situation of stateless children among other Commonwealth countries such as New Zealand and Australia. In addition, bearing in mind that this study is not funded, the lack of access to online articles has been a barrier as well. This is because certain articles are pay-per-view, PPV, and certain databases were not subscribed by the university, such as Journal Storage, or commonly known as JSTOR, and Sage Journals. Furthermore, our study is also limited to the measure we use to collect data. Our study is done mainly, if not solely, on literatures that we were able to find online. We regret that we were not able to interview a member of Malaysia's UHNCR to obtain their view on the current status of stateless children in Malaysia. A direct communication would be able to clarify our doubts or any ambiguities that we might experience during our study. In addition to an interview, we might even get a stance on how UHNCR responds to the rigidity of stateless children in Malaysia, as it cannot be denied that adoption of stateless children would certainly lessen the burden shouldered by the organization. Moving on to Umar, right?
Now, let's move on to our methodology of research. But before that, I would like to first share with you the definitions of doctrinal legal research. According to Aisha Chua, a legal scholar, states that doctrinal legal research deals with the law on a particular issue where the legal doctrine is analyzed as to its development and application. The same but more detailed view is shared by Anwarul Yaqin, who states that doctrinal research is essentially a library-based study, where the material is needed may be available in libraries, archives, and other databases with the aim to discover, explain, examine, analyze, and present in a systematic form, fact, principles, provisions, concept, theories, or the working of certain laws or legal institutions. Next, our research are mainly based on online resources that is provided by the Library of Tun Abdul Razak, UiTM, which is formerly known as PITA. These examples include CLJ Law and other official websites, governmental institutions, Hein Online International Core Collection, ProQuest Dissertation of Thesis, Sage Knowledge, and Scopus. In these online resources, the primary research which can be defined as raw material or first-hand information that we have used include the Federal Constitution, the Child Act 2001, the Adoption Act 1952, reported case from High Court until the Federal Court, as well as the Hansard, and the Registration of Adoption 1952. Meanwhile, secondary sources, which are essentially documents or recordings that relate or discuss information originally presented elsewhere, are also used. For example, journal articles, annotated statutes, conference papers, and textbooks, with the significant to highlight the development of the law and explain the principles encountered in primary sources. Finally, our research also utilizes comparative method, which can be defined as the process of defining, explaining, or utilizing the variances and similarities between two or more legal systems or their relevant integral part, because comparative method comes with its own advantages. Firstly, is the procurement of knowledge of another legal system in order to improve the comprehensive of our own legal system. Secondly, is to be aware of another country's framework that increases the quantity of knowledge. And finally, adds a qualitative different type of knowledge overall from a different country.
Thank you. Now let us move on to the literature review. First and foremost, in regard to granting of citizenship of adopted stateless children, all research articles share the same view that there are no clear and concise provision nor guideline governing this matter. Roslina Chekso expressed that problem occurred when the NRD registered the adoption order of a child with missing parentage whom Malaysian parents adopted as a non-citizen in the birth certificate. It was also shared by Siraj that the 1952 Adoption Act allowed for transferring property right, money, and birth certificate to adopted children. It is unfortunately silent on the transfer of citizenship. Moreover, Raymond submitted that the Court of Appeal has ruled that the word parent in the clause refers to biological parent and that the biological parent or parent must be Malaysian citizen, which is the highest legal precedent for this issue. However, it was argued by Maloshani that Section 9, Subsection 1 of the 1952 Adoption Act state that the adopted child legal position in our legal framework is identical to the status of a biological child. Worth noting that it was agreed by all the researchers that the absence of one definite answer from the federal court on the novel issue due to hindrance of an RD suggesting the aggrieved party in resorting to Article 15A, an absence of legal amendment will create an endless problem to the matter. Moving on to the recommendation made by the studies, Raymond, Mazura, and No Atira shared the same view by suggesting to solely relying on Article 15A that could arbitrarily deprive the right of adopted stateless children. Roslina Chekso take an extreme approach by suggesting DNA testing in determining one nationality. Rodiana and Batmola Shani, on the other hand, suggest a strategic awareness campaign to curb the problem. It's worth bearing in mind that the first suggestion do not solve but only prolong the problem. The second and third suggestion was outside the ambience of legal field. It also shall be noted that none of the researchers had made a comparative study of the issue with the country of New Zealand. Lastly, on effect or legal repercussion facing stateless person, several studies affirm that adopted yet stateless children do not enjoy right of education, public health care, and fundamental liberties. It should be noted that similar literature on the subject had also acknowledged this effect, but fell short in proposing practical legal solution by considering the legal mechanism in any Commonwealth country, specifically New Zealand, so that this problem can be overcome holistically. Now, I would like to pass the floor to my friend Umar.
Thank you, Akmal. Finally, let's move on to the significance of our legal research. First is regarding the significance in legal field, where it will one day serve as a guideline for our MPs in the parliament to propose relevant laws regarding adopted stateless children in Malaysia, since throughout citizenship, it will help disconnected families to live together happily in Malaysia rather than live separately across the globe. Secondly, in the legal field as well, it will one day become a blueprint for future researchers in making new studies regarding adopted stateless children with the legal system of other countries. And it will also hopefully provide a solid backbone for such comparative studies to be made and provide a background information for future researchers in the same topic. Finally, the significance with the United Nations Sustainable Development Goal is to uphold children's rights in Malaysia, since it will make all of them on equal footing to access their rights, such as attending schools, medical health care, and travel overseas. Because this is parallel to the 16th goal of the SDG of the UN, which is to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. In particular, the target to end abuse, exploitation, trafficking, and all form of violence against and torture of children. So that's all from us. Thank you for listening and watching. Now let's move on to the Q&A session.